Here is the uncomfortable truth about construction administration. By the time the building actually gets built, the architect is no longer the smartest person in the room about how it goes together. The superintendent has framed 300 houses. The mechanical sub has installed this rooftop unit 40 times. You drew it once. What the architect retains, and what the AIA contract was very carefully drafted to retain, is procedural authority. You decide what counts as conforming. You certify payment. You answer the questions in writing. You do not tell the contractor how to do the work. Confuse those roles, and you have just stepped into liability the contract was protecting you from. The ARE writes from that line constantly. Here's what the architect actually does in this phase, written tightly. 4 workflows the architect actually owns. First, submittal review. You confirm conformance with design intent, not that the fabricator's dimensions are correct, because means and methods stay with the contractor. Second, RFI processing. The contractor asks for clarification, and you give a written response, but you do not let the RFI become a backdoor change order, because if the answer adds scope, it requires a change order, not a clarification. Third, certification of pay applications. You certify based on observed field progress, not on the contractor's invoice on its own, and a false certification is a representation to the owner that can carry real personal exposure. And fourth, change orders themselves. Scope shifts, time shifts, cost shifts all require signed change orders because the exam tests whether you can keep the work out of the gray zone where nobody can later prove what was agreed. Here's how the 6 subsections build out each workflow. Walking the 6 subsections in order. 2.1 defines the architect's authority in this phase. Limited, contract-bound, and very different from what most architects assume on day 1. 2.2 covers submittal types, shop drawings, product data, samples, mock-ups, and what each one is actually for. 2.3 runs the RFI process, including the trap where a contractor uses an RFI to extract the change without going through change order authority. 2.4 is the change order process itself, with the routing and signatures that turn a verbal agreement into a binding contract amendment. 2.5 is the application for payment, including the G702 and G703 forms, retainage, and what the architect's certification represents. And 2.6 is special inspections, work the building code requires, hired by the owner, but coordinated through the architect. One alignment point before we step into section 2.1. 4 things to anchor before we begin. First, the architect does not direct the work. Every exam answer that puts the architect in a directing role, telling a sub how to install something, telling a superintendent how to sequence, is wrong, even when the answer sounds helpful. Second, means and methods belong to the contractor. The AIA contract is explicit, and the exam writes from the explicit language. Third, conformance review is to design intent, to what the drawings and specs require, not to whether the contractor's measurements are accurate. That is fabrication accuracy, and it sits with the fabricator. And fourth, every CA decision needs a paper trail. Written approval of a submittal, written response to an RFI, written rejection of non-conforming work. A construction administration story told only in voicemails and text messages is a lawsuit waiting to happen. With that posture set, we step into section 2.1. Here's the uncomfortable truth most architects do not want to face. The drawings clearly showed a fire-rated wall, the contractor built a standard partition, and nobody caught it until the fire marshal's final inspection. By then, the wall was buried behind finishes, on the wrong side of a certificate of occupancy that should never have been issued. That story plays out somewhere in this country every week, and it is exactly the kind of failure that construction administration is supposed to prevent. CA is not paperwork. It is your last working opportunity to put eyes on the building before strangers walk into it, sit down to work in it, or sleep in it. If you treat the construction phase as a clerical add-on to the design phases, you are setting yourself up to explain to a deposition why nobody noticed the substitution. The architect who runs disciplined site visits, reviews submittals on the merits, and certifies payments only against work actually in place is the one whose name does not show up on the wrongful death complaint 2 years later. 5 common CA failures connect directly to public harm, and the exam tests every one of them. 5 recurring patterns explain almost every CA failure that ends up on a courthouse docket. The first is the simplest. The architect fails to observe non-conforming work. The substitution stays in the wall, the wrong gauge of steel stays in the joist, and the occupants never learn that the building they trusted was not built the way it was drawn. The second is the submittal that gets a quick rubber stamp instead of a code compliance check. And the third is the change order that resolves a budget squeeze by quietly removing a piece of the life safety system. The fourth pattern is payment certification. The architect certifies progress on a draw that includes work the contractor has not actually finished. And once the money is out the door, the contractor has no incentive to come back and complete the egress lighting or the fire stopping. And the fifth pattern is the architect who crossed the line into means and methods, gave the contractor a direct instruction, and absorbed liability that belonged to someone else. Each one of these is preventable. If you are wondering why this domain shows up so heavily on the exam, the next frame is the answer. CA shows up everywhere on the exam for one reason: public protection. Most architects walk into CA questions confident from the design side and lose points because CA has its own doctrine that does not transfer from how a typical project feels day to day. The boundary words, observe, inspect, supervise, are not synonyms, and you will see all 3 on the same answer set with 1 correct and 2 designed to look correct. Submittal review, RFI response, and payment certification are the 3 exam favorite scenarios because each is a moment where you apply the doctrine cleanly or absorb liability that belonged to the contractor. The wrong answer language itself is a tell. Anything that says the architect supervises, guarantees, or warranties is almost always wrong. Train yourself to recognize that pattern in a second. Pulling all 5 paths together gives you the single sentence to memorize before the exam. 5 takeaways from this opening section. Construction administration is the architect's last independent check before strangers walk into the building, and if it is treated as paperwork, the failures land on real people. 5 failure patterns: non-conforming work that gets a pass, submittals that get a rubber stamp, change orders that quietly remove safety, payment certified for work not in place, and means and methods drift explain almost every CA mistake the exam will test. The ARE hammers this domain because design instincts do not transfer to CA, and the doctrine has its own vocabulary that has to be memorized cleanly. The boundary words, observe, inspect, supervise, are the single biggest source of wrong answer language on the exam, and you should train yourself to spot them in answer choices. And the bottom line is that CA is quality assurance for the public, not a clerical phase, which is exactly why the exam takes it seriously and why your firm's liability tracks how seriously you take it. Walk into any construction defect deposition, and you will hear the same question put to the architect over and over. Did you direct the contractor's work? Most architects, under pressure, want to say yes, because saying no feels like admitting they were not paying attention. But yes is the wrong answer, both legally and contractually. The architect who answers yes gets sued personally on the next page of the complaint, because that one word converts an observer into the contractor's de facto superintendent. Under AIAB 101 Section 3.6, you shift in the CA phase from creator to evaluator. You are no longer the person making decisions about the building. You are the person observing whether the decisions you already made are being implemented. The exam tests this boundary harder than almost any other CA concept, because crossing it is where construction accident lawsuits land on architects who never directed a single nail. 6 things you do during CA. 6 things you absolutely do not. And knowing the line cold is the single most valuable construction administration skill the profession asks of you. Here is the line, written into the B101 contract, 6 on each side. 6 items in each column, and you should be able to recite both columns from memory before exam day. On the left, the things you do. You observe general conformance with the contract documents you wrote. You review and act on submittals. You interpret contract documents when ambiguity arises. You recommend rejection of non-conforming work. You certify applications for payment against work actually in place. And you issue the certificates of substantial and final completion at the end. On the right, the things you do not do, and these are the answer choice traps. You do not supervise construction means and methods. You do not direct the contractor's workforce. You do not guarantee contractor performance. You do not control the construction schedule. You do not approve safety precautions or programs, and you do not make exhaustive or continuous inspections. If the exam puts any of the right column verbs in your mouth, the answer choice is almost certainly wrong. The single biggest place architects cross the line is means and methods. Let me show you the firewall. Per A201, Section 3.3.1, the contractor is solely responsible for means, methods, techniques, sequences, and procedures of construction. The moment you give an instruction that touches any of those 5 words, you have crossed into the contractor's zone and assumed liability for that direction. 4 phrases will get you there fast. Telling the contractor to weld the connection a specific way is means and methods, not design intent. Telling the contractor to schedule the trades in a particular order is sequencing, which belongs to the contractor's superintendent. Telling the contractor which piece of equipment to use on a lift or pour is equipment selection. And telling the contractor to stop work is a directive only the owner has authority to issue. If you find yourself wanting to say any of these, route the substance through an ASI or an RFI response that addresses design intent without specifying how the contractor accomplishes it. Holding the line on these 4 phrases is the single biggest professional liability decision you make every week of California. 5 takeaways. The CA phase, under B101 Section 3.6, makes you an evaluator of work in place, not a construction manager. 6 things you do: observe, review submittals, interpret, recommend rejection, certify payment, issue completion certificates, and 6 things you absolutely do not do, including supervising, directing, and guaranteeing. The means and methods firewall under A201 Section 3.3.1 is what holds the line. Everything about how the contractor builds belongs to the contractor. Crossing the line on a single verbal instruction is enough to absorb the contractor's liability for that direction, which is why the line is drawn so hard. And when you do need to address how the work is built relative to design intent, you route it through a written ASI or an RFI response, never through a verbal direction in the field that nobody can reconstruct 2 years later in a deposition. Here's the question that has ended more architect careers than any design error you can think of. Which verb describes what you do on a construction site? Most architects answer with whatever feels natural in the moment. Supervise, inspect, oversee, manage, and any one of those answers is the wrong answer. Under AIAA 201, Section 4.2.2, you observe the work. You do not supervise it, you do not inspect it, and you do not guarantee it. That is not rhetorical fussiness. That is the legal firewall that separates the architect who reviews progress and gets paid from the architect who absorbs means and methods liability and gets named in the construction accident lawsuit 2 years later. The exam tests this distinction more than any other CA concept because the wrong verb is built straight into the answer choices, and architects who do not train themselves on the terminology walk straight into the trap. 3 terms, 3 different jobs, 3 different frequencies. Keep them straight. 3 terms, 3 different people, 3 different jobs. The architect observes. That means visiting the site at intervals appropriate to the stage of construction and assessing general conformance with the design intent. It does not mean catching every nail or every weld. The special inspector or testing agency inspects. That means detailed examination of specific work for code compliance, typically structural steel welds, concrete placement, post-tensioning, soils, sprayed fireproofing, and seismic systems, on a schedule the code dictates. The contractor supervises. That means directing and controlling means, methods, techniques, sequences, and procedures of construction, every day, continuously, every time a worker is on site. 3 roles, 3 duties, 3 frequencies. If the answer choice on the exam puts the architect in the inspector column or the supervisor column, the answer is almost always wrong. If you want one sentence to memorize, the A201 contract itself gives it to you. This is the sentence to memorize from A201, section 4.2.2. And you should be able to recite it in your head when you read any CA question on the exam. The architect will visit the site at intervals appropriate to the stage of construction to become generally familiar with the progress and quality of the work. Every phrase in that sentence carries weight. Visit the site, not station yourself there. At intervals appropriate to the stage, not daily. To become generally familiar, not exhaustively familiar. With the progress and quality, not with the means and methods. Whenever an answer choice puts a verb in the architect's mouth that is not generally consistent with this language, the answer is wrong by definition. Pulling the 3 terms together leaves you with a single firewall to remember on exam day. 5 takeaways from the terminology firewall. The architect observes. Periodic visits, general familiarity, design intent. The special inspector inspects. Detailed examination for code compliance on a schedule the code sets. The contractor supervises. Continuous direction of means, methods, sequences, and procedures every day on site. A 201 section 4.2.2 is the single sentence to memorize because every wrong answer in this domain on the exam is wrong relative to that sentence. And the most common trap in the entire CE division is the wrong verb answer choice, the one that puts the architect in the inspector or supervisor column when the question is testing whether you know the architect is the observer. Train yourself to scan answer choices for those 3 verbs first, and a meaningful percentage of CE points become free. Most architects treat field reports as administrative housekeeping, something to dictate in the car between site visits, file in the project binder, and forget about. That habit will end the moment you sit through your first deposition. When a construction dispute lands in litigation, the field reports you wrote during CA are read aloud, line by line, by a plaintiff's attorney whose job is to find the gap between what you saw and what you wrote down. You are protected by the reports you wrote contemporaneously and exposed by the reports you did not. The site visit is the architect's primary means of observing construction, and the field report is the contemporaneous record that proves what you observed and what you did about it. Treat every report as if it will be read aloud in court 2 years from now, because in a meaningful percentage of projects, that is exactly what happens. 5 fundamentals govern every site visit you ever make. Get all 5 right, and the rest follows. 5 fundamentals, and every one of them reinforces the observation standard. Frequency is at intervals appropriate to the stage of construction, not daily. You decide when to visit based on what is happening on the job. Foundation pours and structural milestones earn more visits. Routine framing on a 3rd floor that mirrors the first 2 earns fewer. The purpose is to become generally familiar with progress and quality, which is the exact A201 language, and the language you should use in your field reports. Authority belongs to you. The architect decides when to visit, not the contractor calling you to come bless something they want to keep moving. Documentation is the field report, written after every visit, before the details fade. And the limitation, written into the contract, is that you are not responsible for exhaustive or continuous inspection. That limitation only holds if you have not undermined it with your own behavior, which is why disciplined documentation matters. When you sit down to write the field report, here is the 8-item checklist that keeps you out of trouble. 8 items belong in every field report you write, and missing any one of them is the gap a plaintiff's attorney walks through. Date, time, and weather conditions anchor the visit in objective fact. The construction activity observed tells the story of what was happening on the job that day. The number of workers and trades on site captures the manpower picture. The equipment in use captures whether the contractor had the right tools for what they were attempting. Conformance observations, in factual language, describe what you saw, not what you thought. Items requiring attention or correction are flagged for follow-up, not buried in narrative. Photographs are the evidence that does not depend on memory, and conversations with the superintendent or the contractor's project manager are captured so that what was said in the field does not become someone's selective recollection later. Write observed, not inspected, every time you describe what you did. Roll all 8 items together, and the field report becomes your strongest legal defense, not a clerical chore. 5 takeaways from site visits and field reports. Site visits are periodic, with frequency keyed to the stage of construction, not daily, not continuous, not on the schedule the contractor sets for you. The 5 fundamentals, frequency, purpose, authority, documentation, and limitation, all reinforce the observation standard rather than the inspection standard. The 8-item field report checklist gives you the structure to write factually and consistently, and the single most important word in any field report is the verb observed, never inspected. Photographs are the piece of evidence that does not depend on anyone's memory, which is why you take them every visit and label them with the date and the location. And the deepest reason to take field reports seriously is that they are written for a future audience, typically a jury, sometimes a licensing board, that will read your words aloud and decide whether they describe a competent architect doing competent work. Here is the architect's most uncomfortable contractual position. You are paid by the owner, but A201 sections 4.2.11 through 4.2.13 require you to interpret the contract documents and render initial decisions on disputes between the owner and the contractor, impartially. This is not a soft suggestion. It is the express obligation of the architect serving as initial decision-maker under Article 15, and you adopt it the moment you sign B101. The role is quasi-judicial, which is the legal way of saying that the contract treats you, on these specific questions, more like a judge than like the owner's employee. Architects who shade their interpretations toward the party that pays them get sued for bias. And once that pattern of bias is in writing, the architect personally is named in the next lawsuit alongside the firm. The exam tests this point in every CE division because it is the legal foundation for how the AIA contract family expects construction disputes to be triaged before they reach mediation or litigation. 5 situations exercise the architect's interpretive authority, and the boundaries differ in each. 5 situations exercise the architect's interpretive authority during CA. When ambiguity arises in drawings or specifications, you interpret the intent of the documents you produced, and you reduce that interpretation to writing so it cannot be selectively remembered later. When there is a dispute about whether something is in the contract scope, you render an initial decision on what was included. When drawings and specifications are in actual conflict, you determine which controls based on the document hierarchy, which is itself written into Article 1. When the contractor claims a piece of work is outside the contract, you evaluate whether it falls within the scope as originally agreed. And when the dispute is about whether the work as built meets the quality required, you determine whether the in-place work conforms to the contract documents. In every one of these 5 situations, your obligation is to be impartial, and that obligation does not yield to the fact that the owner is the one paying you. When drawings and specs conflict, the hierarchy is not optional. A 201 Article 1 wrote it for you. 4 rules govern how you resolve conflicts between drawings and specifications, and every one of them is written into A201 Article 1. The first is that the contract documents are complementary. What is required by any one of them is binding as if required by all of them, which is the contractual default that keeps trivial inconsistencies from triggering claims. The second is that specifications generally govern materials, quality, and standards of work, because that is the level of detail specifications are written to control. The third is that drawings generally govern dimensions, locations, and geometry, because that is what drawings are built to convey. And the fourth, which architects forget under time pressure, is that you reduce every interpretation to writing through an ASI or an RFI response. A verbal interpretation in the field has 0 contractual weight when the dispute reaches Article 15. Writing it down is what makes the interpretation defensible. Bringing the impartiality obligation and the document hierarchy together is what makes the architect's interpretive role hold up under stress. 5 takeaways from the architect's interpretive role. A201 sections 4.2.11 through 4.2.13 designate the architect as the initial decision maker for disputes between the owner and the contractor, unless the parties have appointed someone else. 5 common situations exercise that authority: ambiguity, scope dispute, drawings versus specs conflict, extra work claim, and quality dispute. And in every one of them, impartiality is the obligation. Impartiality is contractual, not optional, which means the architect does not shade interpretations toward the party paying the fee, and any pattern of shading itself becomes the next dispute. The document hierarchy is the architect's working tool. Drawings and specs are complementary. Specs govern quality and materials, and drawings govern dimensions and geometry. And every interpretation gets reduced to writing through an ASI or an RFI response, because verbal interpretations in the field do not survive contact with Article 15. Here is the conceptual error that sinks more architects on the CE exam than any other: treating submittals as if they were contract documents. They are not. Per AIAA 201 Section 3.12, a submittal is the contractor's demonstration of how the work shown in the contract documents will be built. The fabrication of the curtain wall mullion, the cut sheet for the air handler, the brick sample on the bench. It is the contractor showing his work, not the architect redrawing the project. The line matters legally. The moment you start checking submittal dimensions for accuracy, the moment you scratch out a manufacturer's spec and write in your own number, you have stopped reviewing for design intent and started supervising fabrication. And the contractor's lawyer will use that to argue you are now on the hook for the dimensions you touched. Architects who get this wrong end up named personally in fabrication defect lawsuits where they should have been a witness, not a defendant. 5 categories of submittal show up on every project. Know what each one is and is not. 5 submittal categories cover almost everything you will see in the field. Shop drawings are the contractor-prepared fabrication drawings, structural steel connection details, curtain wall fabrication geometry, and millwork profiles. These are produced by the trade contractor, not the architect. Product data is the manufacturer's cut sheets and performance literature, including equipment spec sheets, safety data sheets, and catalog cuts that prove the product the contractor is buying matches what was specified. Samples are physical pieces of the work, such as a brick, a carpet swatch, a mortar color sample, or a finish chip that you can hold in your hand and judge against the design intent. Certificates are written statements of fact, including installer qualifications, product compliance certifications, and test reports that prove a condition was met without requiring the architect to verify it personally. And design data is the calculation set for any delegated design element, sealed by the contractor's engineer, not by you. One submittal category carries a hidden trap: the mock-up that quietly resets the project's standard of workmanship. Mock-ups are the one category of submittal where a careless review will cost the owner real money for the rest of the project. A mock-up is a physical demonstration, a brick panel, a curtain wall section, a finish assembly, and once the architect approves it, the mock-up becomes the floor for the rest of the work. Whatever workmanship made it onto the mock-up is now the minimum acceptable workmanship for the entire project. Approve a subpar mock-up, and you have just lowered the quality of every wall, every joint, every finish that follows it. Reject mock-ups whose workmanship falls below the specifications. Do not soften the rejection by writing "approved as noted." That locks in the deficiency. And on delegated design submittals, the contractor's engineer holds the seal, which means you are reviewing only for conformance with the performance criteria you wrote. The engineering itself is not yours to second guess, and the liability for it stays with the engineer who sealed it. Pulling the submittal universe together leaves you with one rule that prevents most of the lawsuits in this domain. 5 takeaways from the submittal universe. Submittals exist to demonstrate how the contractor will build what the architect designed. They never replace, modify, or override the contract documents. The 5 categories you will see on every project are shop drawings, product data, samples, certificates, and design data. And each one requires a different review eye. Mock-ups are the silent trap. Once approved, they reset the minimum workmanship for the entire project, so a careless approval lowers the bar permanently. Delegated design submittals carry the contractor's engineer seal, and your review is limited to whether the design intent performance criteria you specified have been met. And the bottom line rule that prevents almost every submittal lawsuit in this domain is to review for conformance with design intent. Never for dimensions, never for quantities, never for the means and methods of fabrication that belong to the contractor. The submittal process is 8 discrete steps, and the exam loves to ask whether you can identify the one step most architects accidentally skip. The answer is step 2, the contractor's own review before the submittal ever reaches the architect's desk. AIAA 201, Section 3.1.2.5 is unambiguous on this point. The contractor must review, approve, and stamp the submittal before forwarding it. If the contractor sends the submittal without a review stamp, the architect's correct response is to return it without action, not to start reviewing it out of professional courtesy. Reviewing an unstamped submittal is how architects get sued for errors that belong to the contractor, because the contractor's lawyer will argue that the architect's review substituted for the contractor's review. 8 steps, 4 parties, 1 liability firewall, and the firewall lives in step 2. Walk the 8 steps in order so the boundary at each one stays visible. Walk the 8 steps in order. Step 1. The contractor prepares the submittal schedule, coordinated with the construction schedule. Step 2. The contractor reviews the submittals. This is the step most architects forget to enforce, and the step where the contractor's responsibility is written into A201, Section 3.1.2.5. Step 3. The contractor stamps and signs each submittal, indicating their review is complete and recorded. Step 4. The contractor forwards the submittal to the architect per the approved schedule, not in a flood and not at the last minute. Step 5. The architect reviews the submittal for conformance with design intent, not for fabrication-accurate dimensions, and not for means and methods. Step 6. The architect takes one of 4 actions: approve, approve as noted, revise and resubmit, or reject. Step 7. If revise or reject was the action, the contractor corrects the submittal and resubmits it. Step 8. Once the action is approve or approve as noted, the submittal returns to the contractor for fabrication and construction use. The chain works only if the routing inside the architect's office works, and most firms do not handle the routing the way A201 expects. Routing matters as much as reviewing, and the architect of record is the conductor, not the soloist. MEP submittals route to the mechanical, electrical, and plumbing consultants on the project. The architect does not review fan coil performance data. The MEP engineer does. Structural submittals route to the structural engineer of record. The architect's job is to coordinate the consultant reviews, consolidate the comments, and return a single, coherent action stamp to the contractor, not 3 competing markups from 3 offices. The second routing reality is cycle control. When a submittal cycles 3 or more times without converging, something is wrong upstream. Either the contract documents are ambiguous, or the contractor is not absorbing the comments, or the design team is sending inconsistent feedback. Each unproductive cycle is a delay claim waiting to happen and a deposition question waiting to be asked. And the third reality, written straight into A201 Section 4.2.7, is that the architect's review is for the limited purpose of checking conformance with the design concept. It never relieves the contractor of responsibility for the submittal's accuracy. Pulling the 8 steps and the routing together leaves you with one rule that holds the liability line. 5 takeaways from the submittal review process. 8 steps in order: schedule, contractor review, stamp, submit, architect review, action, correct, return. And the exam tests whether you can place each step with the correct party. Step 2 is the liability firewall. The contractor must review and stamp the submittal before sending it, per A201, Section 3.12.5. And forgetting that step is the single most common error new architects make in their first year of CA. Return unstamped submittals without action. The temptation to be helpful and start reviewing is exactly how architects get sued for the contractor's errors. MEP submittals route through the MEP consultants and structural through the structural engineer first, because the architect of record is the conductor of the review, not the reviewer of every discipline. And the architect's review is bounded, per A201 Section 4.2.7. The review is for design intent conformance only, and the contractor's responsibility for the accuracy of the submittal does not transfer no matter what stamp ends up on the page. Most architects treat the stamp at the bottom of a submittal like initialing a memo. A quick mark, then move on. That habit is exactly what gets you sued. The stamp is contractual language, and the architect who treats it as a clerical formality absorbs the consequences. 4 standard actions exist under AIAA 201, Section 4.2.7, and the difference between them is not stylistic. Approve and approve as noted both let the contractor proceed with the work. Revise and resubmit and reject both stop the work pending a fix. But within those 2 pairs, the distinctions matter enormously, and the one that gets architects in the most trouble is approve as noted on a submittal that contains a substantive deviation from the contract documents. The contractor proceeds, the deviation becomes the as-built condition, and 3 years later, somebody is in a deposition explaining why a contract modification was processed through a submittal stamp rather than a change order. That architect personally is in the lawsuit because the stamp on the page contradicted the contract documents and nobody caught it. Walk the 4 stamps in order, meaning action, and the trap each one carries. 4 stamps, 4 meanings, 4 consequences for the contractor's next move. Approved, or no exceptions taken, means the submittal conforms to design intent. The contractor proceeds with fabrication or construction as shown. Approved as noted means the submittal substantively conforms, but minor corrections are noted on the face of the submittal. The contractor incorporates the noted corrections and proceeds without resubmitting. Revise and resubmit means significant issues exist. The contractor corrects the deficiencies and submits a revised package for another full review cycle, and the work covered by this submittal cannot proceed until that cycle completes. And rejected, or not approved, is the strongest stamp. The submittal does not conform at all, the existing submittal cannot be salvaged, and the contractor must prepare an entirely new submittal from scratch. The exam will test whether you can match each stamp to the correct downstream action. So commit the 4 pairings to memory. Many modern firms have shifted the stamp language itself, and the shift carries a deliberate liability calculation. Many modern firms have replaced the word approved with the word reviewed, and the change is not cosmetic. Reviewed, no exceptions taken, reinforces that the architect's action is a review for design intent conformance, not an approval of the contractor's fabrication, dimensions, or means and methods. The change in language tracks the contractual reality already written in A201, Section 4.2.7, but the word reviewed makes it harder for a plaintiff's lawyer to argue that an architect's approval guaranteed the work. The 2 stamps function identically for the contractor. Both permit work to proceed, but they speak differently to a jury. Approved sounds like an architect's warranty. Reviewed sounds like an architect's check against the design concept. On legacy projects and on federal work, the older approved as submitted language is still required by the contract, so you do not unilaterally switch. You use what the contract demands. But on private sector work, where you control the stamp language, reviewed is the safer word for the architect personally and for the firm. Pulling the stamp universe together leaves one rule that prevents most submittal-related lawsuits. 5 takeaways from the stamp universe. 4 standard actions exist: approve, approve as noted, revise and resubmit, and reject, and each one routes the contractor to a different next move. Approve as noted is the dangerous stamp when the submittal contains a substantive deviation from the contract documents. Route any deviation that materially changes the work through an ASI, or if cost or time is affected, through a change order. Modern firms have shifted from approved to reviewed in their stamp language because the word reviewed reinforces the architect's observer role and weakens the plaintiff lawyer's argument that the architect guaranteed the fabrication. Stamp language never relieves the contractor of responsibility for accuracy, dimensions, or means and methods. That limitation is written straight into A201, Section 4.2.7, and the architect's review cannot override it. And the bottom line rule that prevents most submittal-related lawsuits is to never let a contract modification slip through on a submittal stamp. Modifications run through change documents, not through review marginalia. Here's the schedule arithmetic that surprises every architect on their first large project. A long lead submittal sitting on a desk for 2 weeks does not delay the job by 2 weeks. It delays the job by months. Switchgear, structural steel, custom curtain wall, elevators, and certain large HVAC units carry lead times of 12 to 40 weeks, and fabrication does not begin until the submittal is approved. 2 weeks of inattention in the architect's office becomes 2 extra weeks added to the back end of a 40-week fabrication clock. And the contractor sues for delay damages because the contract said the architect would respond with reasonable promptness. AIAA 201 Section 3.12 requires the contractor to prepare a submittal schedule coordinated with the construction schedule, and it requires the architect to review with reasonable promptness. Both directions are contractual obligations, not professional courtesies. Miss the schedule, and the lawsuits start finding their addresses. 6 responsibilities split between 2 parties, and the exam tests whether you know which party owns which line. 6 responsibilities split cleanly between 2 parties, and the exam will test whether you can place each one. The contractor prepares the submittal schedule. The contractor coordinates that schedule with the construction schedule. The contractor submits according to the approved schedule, and the contractor identifies and flags long lead items at the pre-construction meeting so the design team knows which submittals carry the most schedule risk. The architect reviews and approves the submittal schedule, meaning the architect checks that the contractor's schedule is compatible with the design team's review capacity and flags any compressed windows that would not allow a reasonable review. And the architect reviews each submittal with reasonable promptness, which in most contracts works out to 10 to 14 business days. If the exam puts the architect in the prepare column, the answer is wrong. If it puts the contractor in the review and approve column, the answer is wrong. 2 parties, 6 lines, clean ownership. 6 failure modes show up on almost every project, and 4 of them are the architect's chance to refuse the submittal. 6 failure modes appear on almost every project, and 4 of them give the architect a legitimate basis to refuse the submittal. Submitting too many at once overwhelms the review queue and is grounds to push back on the contractor's schedule. Submitting too late delays construction, and if the contractor then claims the architect's review caused the delay, the fault lies with the contractor, whose schedule was never coordinated in the first place. Not coordinating between trades produces conflicts that surface during architect review, and those conflicts properly belong back in the contractor's coordination process, not in the architect's markup. Forwarding submittals without the contractor's review stamp is the clearest refusal trigger. A 201 Section 3.1 2.5 requires the contractor's review, and the architect returns the unstamped submittal without action. Resubmitting without addressing prior comments wastes a cycle and signals that the contractor is not reading the review. And front-loading submittals, sending everything in the first month, regardless of when the trade is actually built, distorts the schedule and is grounds to require the contractor to resequence. Pulling the schedule and the failure modes together leaves one rule that holds the architect's position. 5 takeaways from the submittal schedule. The contractor prepares the schedule and the architect reviews and approves it. That ownership split is written into a 201 Article 3, and the exam tests it every cycle. Long lead items drive the schedule, so identify them at the pre-construction meeting and put them at the front of the queue. Switchgear, structural steel, custom curtain wall, elevators, and large HVAC units have lead times measured in months, not weeks. The architect's review window is typically 10 to 14 business days, which is the contractual translation of reasonable promptness in most agreements. Return unstamped submittals without action per a 201 Section 3.1 2.5. The contractor's review is a contractual prerequisite, not a courtesy. And if the contractor submits late and then claims the architect's review time caused a delay, the fault is the contractor's, by definition. The schedule should have been coordinated with the construction schedule before the first submittal ever left the office, and a lawsuit on that claim almost always fails. Most architects on a site walk get cornered by the same question every Tuesday afternoon. The contractor's superintendent points at a conflict, asks what to do, and waits for a quick answer. Give that quick answer verbally, and you have just handed the contractor's lawyer a gift, an undocumented instruction that you cannot reproduce, and the contractor can characterize however he likes when the lawsuit shows up. The RFI exists for exactly this reason. Per AIAA 201, Section 4.2.11, the contractor's mechanism to seek clarification of the contract documents is a written request for information, and the architect's response is a written interpretation of those documents. Both directions are written. Both directions are logged. Neither one is verbal. If the field crew is pressed for an immediate answer, the right response is to give a tentative reading and then say, "Please submit this as an RFI today so we can confirm in writing." The written record is what protects the architect from being sued for an instruction that never happened the way the plaintiff later claims it did. Walk the 7 steps so the boundary between contractor question and architect interpretation stays clean. Walk the 7 steps in order. Step 1. The contractor identifies the need for a clarification, an ambiguity in the drawings, a conflict between 2 trades, a piece of information that is missing from the documents. Step 2. The contractor submits a written RFI with 1 specific question per request, not a list of unrelated questions that will produce a tangled response. Step 3. The architect logs the RFI with a sequential number, the date received, and the expected response date. Step 4. The architect prepares the response, consulting subconsultants on discipline-specific issues. The MEP engineer answers MEP RFIs, not the architect of record. Step 5. The architect issues the written response within the agreed timeframe, which in most projects is 7 to 10 business days. Step 6. The contractor evaluates the response. If it changes the cost or the time, the contractor notifies the owner and the matter routes into the change order process, not back into another RFI. And Step 7. The response is logged and distributed to every party affected by the clarification, so the record is complete. A well-formed RFI is itself a quality control test. 5 elements separate the useful from the unanswerable. 5 elements separate a useful RFI from one that wastes a review cycle. The RFI number and date give every party a fixed reference point for tracking and for the eventual project record. A single specific question is the discipline most contractors need to learn. When an RFI asks 5 vague concerns at once, the response is necessarily 5 vague answers, none of which actually closes the loop. A precise reference to the spec section and the drawing detail in question tells the architect exactly which contract documents are at issue and prevents the response from talking past the question. The contractor's proposed solution, when offered, gives the architect a starting point and demonstrates that the contractor has actually thought about the conflict before sending the RFI. And the response needed date with supporting photos or marked up drawings makes the urgency visible and gives the architect something concrete to evaluate. RFIs that miss these elements come back through the cycle 2 or 3 times before resolution. Wasted review time, missed deadlines, and lawsuits where the contractor claims architect caused delay. Pulling the process and the anatomy together leaves one rule that protects the architect from the verbal answer trap. 5 takeaways from the RFI process. RFIs exist to clarify the existing contract documents. They never modify the documents. And when a response would add cost or time, the matter routes into the change order process instead. The 7-step chain runs from contractor identification through architect response and distribution, with one party owning each step cleanly. If an RFI response would change the cost or the time, the contractor notifies the owner, and the issue becomes a change order matter, not a second RFI that quietly modifies the contract. Verbal field answers are the architect's single biggest source of avoidable lawsuits in this domain. Every verbal answer becomes an undocumented instruction the architect cannot reproduce, and the discipline is to convert every verbal exchange into a written RFI the same day. And the 5-element anatomy: number, single question, precise reference, proposed solution, response needed date, is the quality test that prevents RFIs from cycling 3 times before producing a usable answer. Most architects can name the difference between an RFI and an ASI on a good day. But under exam pressure, the two start to blur, and the blur is exactly where the wrong answer lives. An RFI flows from contractor to architect. The contractor asks, the architect answers. An ASI, the architect's supplemental instruction, flows in the opposite direction. The architect issues, the contractor receives. That is the easy half. The harder half is the contractual ceiling on the ASI. Under A201, Section 7.4, an ASI cannot change the contract sum or the contract time. The moment the supplemental instruction would adjust cost or schedule, the correct document is a change order, not an ASI. Architects who issue ASIs that quietly add cost get sued personally for exceeding their authority under the agreement because they have effectively modified the contract on behalf of an owner who never signed off on the modification. The side-by-side reads cleanly once the 4 columns are visible: purpose, initiator, mechanism, ceiling. Side by side, the documents read cleanly. An ASI is initiated by the architect. An RFI is initiated by the contractor. Both serve the same fundamental purpose: to clarify the contract documents that already exist. But they travel in opposite directions through the project hierarchy. Neither document, by itself, can change the contract sum or the contract time. That is the contractual ceiling on both of them, written into A201 Section 7.4 for the ASI and into Section 4.2.11 for the RFI response. The moment the clarification would adjust the price or the schedule, the matter routes out of both documents and into the change order process. The exam tests this pair as a unit, because architects under pressure will sometimes try to use an ASI as a quick and easy way to authorize a small extra, and that is exactly the trap. There is no such thing as an ASI that adds money. If money is added, it is a change order. When an RFI reveals a design error, the architect's next move is one of the most exam-tested sequences in CA. What happens when the contractor's RFI exposes an actual design error, not an ambiguity, but a mistake, is one of the most heavily tested sequences in the CE division. 5 moves, in order. Acknowledge the error. The instinct under stress is to argue that the contractor misread the documents, but concealment becomes the basis for the malpractice lawsuit when the error surfaces later anyway. Prepare corrective documents, and the document choice matters. If the correction can be made without changing the cost or the time, an ASI is the right vehicle. If cost or time changes, a change order is required. Notify the owner promptly of any cost or schedule implications, because the owner is the one whose contract is being modified, and the owner's consent is required for the modification to be enforceable. Document the issue and the resolution in the project record, because 2 years from now, a deposition will ask exactly when the error was discovered and what was done about it. And notify the firm's professional liability carrier for significant errors. Most policies are claims made and require timely notice, and a late notice can void coverage exactly when the firm needs it. Pulling ASI and RFI together leaves one rule that prevents most of the lawsuits in this domain. 5 takeaways from the ASI and RFI universe. The ASI flows from architect to contractor, and the RFI flows from contractor to architect. Opposite directions, complementary functions, and the exam tests whether you can place each one. Neither document can change the contract sum or the contract time per A201, Section 7.4, and the parallel language in Section 4.2.11. And the architect who issues an ASI that quietly adds cost has exceeded contractual authority. When a clarification would add cost or time, the matter routes to a change order, full stop. There is no expanded ASI that captures the change. When an RFI reveals a design error, the 5-step sequence is acknowledge, correct, notify owner, document, and notify the professional liability carrier for significant errors. And the discipline that holds the system together is a numbered RFI log, reviewed at every owner-architect-contractor meeting, so nothing falls through the cracks and becomes the basis of a contractor delay claim. Most architects underestimate what an unanswered RFI costs the firm. AIAA 201, Section 4.2.11 requires the architect to interpret and respond to matters of contract performance with reasonable promptness. Reasonable promptness sounds soft until the contractor's lawyer puts it on a timeline and shows the arbitrator that a critical path RFI sat on the architect's desk for 31 days, while 6 dependent trades stood idle. At that point, reasonable promptness is whatever the arbitrator decides was reasonable, and the firm pays for the difference, either through a back charge in the next pay application or through an insurance claim that drives next year's premium through the roof. The architects who win this argument are the ones who pinned a number to the phrase in writing at the pre-construction meeting and then tracked it. Reasonable promptness needs to be a number on a calendar, not a feeling in the architect's gut, or you will lose the delay claim every time it goes to a panel. 5 elements of a defensible RFI response standard. Get all 5 into the supplementary conditions. 5 elements of a defensible RFI response standard, and each one needs to live in the supplementary conditions, not in the architect's memory. Response time should be a defined number of business days, 7 to 10 in most projects, so that reasonable promptness has a known meaning and neither party can invent a definition after the fact. Format is written, referencing the specific drawings and specifications at issue. A verbal answer in a job site trailer has zero contractual weight and frequently turns into a deposition exhibit 2 years later. Distribution goes to every party affected by the clarification: the contractor of record, the relevant subcontractor, the owner if cost or time is implicated, and every design team member whose work is touched. Documentation lives in a numbered RFI log with the full response history, including every cycle if the RFI cycled more than once. And subconsultant coordination is the architect of record's responsibility. MEP ref is route to the MEP engineer first, structural ref is route to the structural engineer first, and the architect consolidates a single coherent response. 4 hard moves at pre-construction lock the response window so it cannot be litigated later. 4 hard moves at pre-construction will prevent almost every delay claim lawsuit in this domain. First, define the RFI response window in the supplementary conditions, not in a project procedures memo that nobody signs. 7 to 10 business days is the most common range, and the supplementary conditions are part of the contract. They have contractual weight that a project procedures document does not. Second, confirm the window at the pre-construction meeting and put it in the meeting minutes signed by the contractor's superintendent. That gives the firm a date-stamped acknowledgement that everyone agreed to the same number. Third, track open RFIs by remaining response days, not just by submission date. The RFI submitted 3 days ago with 2 days left to respond is the one that needs attention now, not the one submitted yesterday with 8 days to go. And fourth, honor the contractor's critical path flag. When the contractor identifies an RFI as critical path, the architect either responds within the expedited window or accepts that a delay claim on that RFI is fully justified. The discipline is to know which one you are doing and to make the choice consciously. Pulling the time pressure together leaves one rule that holds the architect's professional liability position. 5 takeaways from RFI response timing. AIAA 201 Section 4.2.11 sets the legal standard at reasonable promptness, but the contractual definition lives in the supplementary conditions. Pin a number there, typically 7 to 10 business days, or you will fight that number in front of an arbitrator. Late RFI responses become the contractor's single strongest delay claim, and a critical path RFI past its window is almost guaranteed to produce compensable delay damages that the firm absorbs through back charges or insurance premiums. Track open RFIs by remaining response days, not by date submitted, because the management question is which RFI will go past its deadline first, not which RFI has been open longest. Honor the contractor's critical path flag. When the contractor identifies an RFI as critical path, you either respond within the expedited window or you knowingly accept the delay claim exposure. And the meta takeaway? Reasonable promptness is a number on a calendar, not a feeling, and architects who treat it as a feeling get sued for the delay damages every time. Here is the rule most architects on their first large project get wrong, and the one the exam tests every cycle. A change order requires 3 signatures: owner, contractor, architect. AIA document G701 is the formal change order form, and all 3 signature blocks must be executed for the change to be binding. 2 signatures is not a change order. It is a proposal that has not been authorized. The reason all 3 parties sign is that a change order is a modification of the contract. The owner consents because his contract is being amended. The contractor consents because his scope is being expanded or reduced. And the architect signs to confirm the change is consistent with the design intent and that the documentation is complete. The contractor who starts work on a proposal request before the CO is signed has worked without authority. And the firm that processes a change order with 2 signatures and lets the work proceed has just exposed itself to a lawsuit when the owner refuses to pay for unauthorized work 2 months later. Walk the 8-step sequence so the role of each party at each step stays visible. Walk the 8 steps in order and notice where each party owns the action. Step 1. The change need is identified. And importantly, the trigger can come from any party. The owner identifies a programming change. The architect identifies a design coordination issue. Or the contractor identifies a field condition that differs from the documents. Step 2. The architect issues a proposal request describing the proposed change to the contractor. Step 3. The contractor prepares a cost and time proposal, including subcontractor pricing and schedule impact. Step 4. The architect reviews the proposal for reasonableness, neither approving nor rejecting on the merits, but evaluating whether the pricing and time are within the range a competent contractor would reasonably charge. Step 5. The architect recommends to the owner whether to proceed, and the owner makes the actual decision. Step 6. If the owner authorizes, the change order on AIAG 701 is prepared. Step 7. 3 signatures are executed: owner, contractor, and architect, and only at this point is the contract modified. And Step 8. The changed work proceeds under the modified contract terms. Skip Step 7 and the work is unauthorized. Proposal requests are the step most contractors misread, and the misread is grounds for refusing payment later. The proposal request is the step contractors most often misread, and the misread is exactly the grounds the owner needs to refuse payment for unauthorized work. A proposal request is a request for pricing, nothing more. It is the architect saying, "Here's a change we are considering. Tell us what it would cost and how it would affect the schedule." The contractor responds with cost and time, but the response is itself a proposal, not authorization to proceed. The architect evaluates the proposal for reasonableness, but the architect cannot authorize the change either. The architect's role is to recommend to the owner. The owner makes the final call. And only when the owner has authorized the change does the change order get drafted, signed by all 3 parties, and executed. If the contractor reads the proposal request as a green light and starts work, that work is unauthorized, and a sophisticated owner can refuse to pay for it. Architects who let proposal requests sound like directives, by using imperative language or by failing to make the request versus authorization line explicit, set their projects up for exactly this dispute. The discipline is to label proposal requests as proposal requests and to be explicit in writing that they are not directives. Pulling the 8 steps and the proposal request trap together leaves one rule that holds the change order discipline. 5 takeaways from the change order process. Change orders require 3 signatures: owner, contractor, and architect, and AIAG 701 has all 3 signature blocks for that reason. 2 signatures is not a change order. It is an unauthorized modification. The 8-step sequence runs from identification through signed authorization and changed work, with the owner making the actual decision in the middle of the sequence and the architect playing a recommending role, not a deciding role. Proposal requests are not authorizations to proceed. They are requests for pricing, and contractors who treat them as directives perform unauthorized work that the owner can refuse to pay for. The decision authority sits with the owner, the recommending authority sits with the architect, and the pricing and time impact come from the contractor. And the exam tests whether you can place each one in the correct lane. And cumulative impact, the way a series of individually small change orders can collectively disrupt the contractor's productivity, is grounds for a separate claim that no single change order captures. So review the running CO log at every owner-architect-contractor meeting and flag the moment the cumulative effect warrants its own evaluation. Most architects walk into the CE exam confident on change orders and lose points on the related question that asks which change instrument applies when. 3 documents exist, and the exam tests whether you can match each instrument to its specific situation. The ASI is for an architect-issued clarification consistent with the existing documents. No change in cost, no change in time, signed by the architect alone. The change order is for an agreed change that does affect cost or time, signed by all 3 parties on AIAG 701. And the Construction Change Directive, the CCD AIAG 714, is the document the exam loves because it is the unusual one. The owner needs the work done now, the contractor has not yet agreed on the price, and the owner directs the contractor to proceed anyway. The CCD is signed by owner and architect only, not by the contractor, and the contractor is contractually obligated to comply while the cost gets resolved afterward. 3 documents, 3 signature patterns, 3 situations. Confuse them and the firm gets sued for unauthorized direction. The side-by-side reads cleanly once the 4 columns are visible. Situation, signatures, cost time impact, and when each one applies. Walk the 3 rows side by side and the differences become obvious. The minor change, issued on AIAG 710 as an ASI, is used when the architect needs to clarify something consistent with the existing documents. No cost change, no time change, architect signature alone. The Construction Change Directive on G714 is used when the owner needs work to proceed now, but the contractor has not yet agreed on the price, and it carries owner and architect signatures only. The contractor does not sign the CCD because the contractor has not yet agreed. That is the whole point of the document. The change order on G701 is used when all parties have agreed on scope, cost, and time, and all 3 parties sign. The signature pattern is the easiest tell on an exam question. Architect alone is ASI, owner plus architect is CCD, and all 3 is change order. Match the signature count to the document, and most of the trap answers fall away. The CCD is the unusual one. Proceed now, pay later. And the exam loves to test exactly how it works. 5 things you need to know about the CCD, and each one is exam testable on its own. First, the CCD exists precisely because some changes cannot wait for negotiation. The owner discovers a structural concern that has to be addressed today to keep the project moving. The contractor wants more money than the owner thinks is fair, and waiting for agreement would idle the project for weeks at a cost the owner cannot absorb. Second, the CCD is signed by owner and architect at issuance. The contractor does not sign because the contractor has not agreed on the price. Third, the contractor is contractually obligated to comply under AIAA 201, Section 7.3, regardless of the pricing dispute. Fourth, the cost is determined later, through negotiation between owner and contractor, and if that fails, through the Article 15 dispute resolution process, with the architect serving as initial decision maker. And fifth, the ASI cannot substitute for a CCD when cost is involved. An ASI that quietly directs cost-bearing work is the architect personally being sued for unauthorized modification of the contract. Pulling the 3 instruments together leaves one rule that prevents most of the wrong document lawsuits in this domain. 5 takeaways from the 3 change instruments. The ASI on G710 is the architect alone document, used when the clarification has no cost or time impact and the change stays inside the existing contract envelope. The CCD on G714 is the owner plus architect document, used when the owner needs work to proceed before the contractor has agreed on price, and the contractor must comply while the cost is resolved through subsequent negotiation. The change order on G701 is the all 3 parties document, used when scope, cost, and time are all agreed up front. The owner is the only party who can authorize a change that affects cost or time. The architect recommends, the contractor proposes, but the owner alone decides whether to spend the money. And the memory hook that solves most of the document matching questions on the exam is the signature count. 1 signature is an ASI, 2 signatures is a CCD, 3 signatures is a change order. And any answer choice that puts the wrong number of signatures on the wrong document is wrong by definition. Most architects sign change orders the same way they sign expense reports, focused on the dollar amount, not the language around it. That habit is the change order trap that catches more architects than any other in the CE domain, signing a change order without release language. The contractor signs the CO for the direct cost of the change. The work proceeds, and 6 months later, the same contractor files a separate claim for cumulative impact, schedule disruption, or lost productivity attributable to the same change. The owner is furious. The architect is in a deposition explaining why the CO did not include accord and satisfaction language, and the firm's professional liability carrier is the one writing the check. Owners often insist on release language. Contractors often resist it, and the architect is the one in the middle who has to flag the absence of release language as a discussion item before signing. A complete change order is more than a description of the work and a dollar amount. It is a contract modification with 6 required elements, and missing any one of them creates a hole the contractor's lawyer drives the claim through 18 months later. 6 required elements separate a complete change order from one that produces lawsuits. 6 required elements separate a complete change order from one that produces a lawsuit. The description of the changed work has to define exactly what is being added, deleted, or modified. Vague descriptions like additional electrical work in the basement become the basis for a scope dispute about which conduit runs were actually included. The change in contract sum documents both additions and credits in dollars, so the cost accounting closes. The change in contract time documents days added or reduced because the CO modifies both the sum and the time, and forgetting the time component leaves the schedule ambiguous. Supporting documentation, the contractor's proposal, the architect's review, the owner's approval, proves how the parties got to the agreed terms and survives a deposition 5 years later. 3 signatures execute the modification, and the reference to the original documents identifies which drawings and specifications are affected, so the as-built record is unambiguous. Skip any one of these and the CO is incomplete, and incomplete change orders are the lawsuits the firm gets sued over. 4 cost methods exist under A201, and the markup discipline matters as much as the method itself. 4 cost methods exist under A201, and the choice affects how easily the CO can be verified. Lump sum is the cleanest method when the scope is well defined. The contractor and owner agree on a fixed price, the work happens, the CO closes. Unit prices apply when quantities will vary, but rates are pre-established in the contract, typical for earthwork, asphalt, and concrete by the cubic yard. Cost plus a fee is used when the scope is uncertain. The contractor charges actual costs and adds an agreed markup, and the architect's verification job is to confirm that the costs were actually incurred. Time and material is the least preferred method because it is the hardest to verify and the slowest to close. Labor rates plus material costs with no fixed ceiling. And across all 4 methods, the markup discipline is the same. Verify the proposed markup against the contract caps written into the supplementary conditions. Standard caps are typically 15% on direct work and 5 to 10% on subcontractor work, and the architect's job is to flag double markup, the general contractor marking up the subcontractor's already marked up price, because double markup is one of the most common forms of overcharging the firm sees on a busy project. Pulling documentation and cost methods together leaves one rule that prevents most CO lawsuits. 5 takeaways from change order documentation. The 6 required elements, description, change in sum, change in time, supporting documentation, 3 signatures, and reference to the original documents are the minimum content for a complete CO, and missing any one of them creates a hole somebody's lawyer will use to argue ambiguity later. 4 cost methods exist under A201: lump sum, unit prices, cost plus fee, and time and material, and the choice depends on how well the scope is defined when the CO is being written. Verify the proposed markup against the contract caps in the supplementary conditions, and watch carefully for double markup on subcontractor work, which is one of the most common forms of overcharging in the field.
Flag the absence of release language as a discussion item before signing. Without accord and satisfaction language, the contractor signs for the direct cost and retains the option to sue for cumulative impact 6 months later, and the firm pays for that gap. And maintain a running CO log showing cumulative dollars and time impact across every pay app cycle, because the running log is what tells the architect when cumulative impact warrants its own evaluation, rather than being buried inside individual COs. Most architects assume the strength of a claim is about the merits, the facts, the documents, the expert testimony. You will be wrong about that on the exam, and you will be wrong about it in your first major dispute. The procedural cliff that kills more meritorious claims than any other defect in construction practice is the 21-day notice under AIAA 201, Section 15.1.3. A contractor discovers a differing site condition on day 1, decides to assess the situation before filing, drafts a careful claim on day 25, and the lawsuit is dead on arrival. Not because the claim lacks merit, not because the differing condition was not real. The contractor loses because the notice was untimely, and 21 days is a hard procedural deadline that the contract does not extend on equitable grounds. The architect's role in this domain is the initial decision maker under a 201 Section 15.2.1, and the architect's first job when a claim arrives is to confirm the notice was timely, because if it was not, the procedural defense disposes of the claim before the merits are reached and saves the owner from paying a meritorious but late claim. 5 steps run from notice through binding resolution. Walk them in order so the architect's role at each step stays clear. Walk the 5-step ladder so the architect's role at each step stays visible. Step 1, the claimant, owner or contractor, gives written notice within 21 days of the event giving rise to the claim per A201 Section 15.1.3. The notice is the procedural prerequisite, and a late notice fails the claim before anyone reads the merits. Step 2, the initial decision maker, which is the architect by default unless the parties named someone else, takes initial action within 10 days under Section 15.2.1. The action is one of 3: request more information, render a decision on the merits, or recommend a compromise. Step 3, the IDM renders a decision. The decision is not final, either party can reject it, but it carries weight and frames the subsequent proceedings. Step 4, if either party rejects the IDM's decision, mediation is mandatory before further proceedings. Skip mediation and the arbitration or litigation can be stayed until mediation occurs. And step 5, if mediation fails, the parties proceed to binding resolution. Arbitration is the A201 default, but the parties may have specified litigation in the supplementary conditions. Through every one of these 5 steps, A201 Section 15.1.4 requires the work to continue. The party that stops working during a dispute becomes the party in breach. 4 hard rules separate parties who survive the ladder from parties who lose on procedural defaults. 4 hard rules separate parties who survive Article 15 from parties who lose on procedural defaults and get sued for the consequences. First, 21 days, no extensions. The moment the triggering event is known, the clock starts, and a partial notice that preserves the right to amend is the right move. Waiting for certainty and filing on day 25 ends the claim. Second, work continues throughout, per A201 Section 15.1.4. Neither party may stop performance because of a pending claim, and the party that pauses becomes the party in breach. This is one of the most common misconceptions on the exam. A disputed claim does not pause the work, and stopping performance is itself a lawsuit waiting to happen. Third, mediation is mandatory before binding resolution. A party that skips straight to arbitration can have the arbitration stayed until mediation occurs, costing months of delay and additional damages.
And fourth, the IDM decision is not final, but carries weight. Reject it deliberately, not reflexively, because parties who reject a well-reasoned decision without substantive grounds often find themselves on the wrong end of the arbitrator's eventual award. Pulling the latter and the four rules together leaves one principle that holds the architect's position as IDM. 5 takeaways from Article 15. The 21-day written notice under Section 15.1.3 is the procedural gate, a hard deadline that kills meritorious claims when missed, and one of the highest yield rules on the exam. The initial decision maker, the architect by default, takes initial action within 10 days under Section 15.2.1, and the architect's impartiality obligation applies even though the owner pays the fee. Mediation is mandatory before binding resolution. A party who skips to arbitration directly will have the arbitration stayed until the mediation occurs, which costs time and often produces additional delay damage exposure. Binding resolution is arbitration by default under A201, or litigation if the supplementary conditions specify it, and the choice is made when the contract is signed, not when the dispute arises. And the rule that catches more parties than any other? Work continues throughout the dispute under Section 15.1.4. Stopping work because of a pending claim is itself a breach, and the party that pauses performance gives up the contractual high ground on the underlying claim. Most architects glance at the payment process as a clerical step, and then their firm loses an insurance claim that nobody saw coming. The word in AIAA 201, Section 9.4 is certify, not approve, not guarantee, not warrant. The architect certifies that, to the best of the architect's knowledge, the work has progressed to the point indicated on the application for payment, and the quality is generally in accordance with the contract documents. That phrase is what a plaintiff's lawyer reads to a jury 2 years later when the building has a defect. And the lawyer's argument is that the architect's certification stood behind the work that turned out to be defective. The defense is the words, to the best of the architect's knowledge, a professional representation, not an absolute guarantee. But the defense only works if the architect actually performed the certification responsibly, reviewing the application against the schedule of values, comparing it to observed progress on site, evaluating any stored materials claimed, and certifying only the amount that matches what is actually in place. Certify for work not in place, and the certification is the architect's signature on the future lawsuit. 6 steps run from contractor application through owner payment. Walk them so the architect's responsibility at each step stays visible. Walk the 6 steps so the architect's responsibility at each step stays visible. Step 1. The contractor submits an application for payment, which consists of AIAG 702, the application itself, and G 703, the continuation sheet that breaks the schedule of values into line items and reports the percent complete on each one. Step 2. The architect reviews the application against the schedule of values approved at the start of construction and against observed progress on the site. The review is line by line, not a holistic glance, because each line item is its own representation about the state of the work. Step 3. The architect evaluates any stored materials claimed in the application, on-site or off-site, and applies the contract's documentation standards before crediting them. Step 4.
The architect issues the certificate for payment by signing the lower portion of G702 for the certified amount, which may be less than the amount applied for if the architect's review identified work not in place. Step 5. The owner pays the contractor within the contract specified timeframe, typically 30 days. And Step 6. The process repeats monthly through the project duration. Each cycle is a fresh certification, with the architect's professional liability renewed each month. G702 and G703 trip up architects on the exam because the document names sound similar, but the roles are split. G702 and G703 trip up architects on the exam because the document names sound similar and the roles are split between the two parties. The schedule of values, which is part of G703, is prepared by the contractor at the start of construction and approved by the architect. The contractor breaks the contract sum into line items that will be tracked through the project, and the architect approves the breakdown as reasonable. The application for payment itself, G702, is prepared by the contractor monthly. The continuation sheet, G703, is also prepared by the contractor. It is the line-by-line percent complete breakdown for that month's application. And the certificate for payment, which sits at the bottom of G702, is signed by the architect. The architect is not preparing the form, but the architect is the party who certifies it. The exam favorite is who prepares G702 versus who issues the certificate for payment. The contractor prepares, the architect certifies. If an answer choice puts the architect in the prepare column or the contractor in the certify column, that answer is wrong by definition. Pulling the cycle and the document roles together leaves one rule that holds the certification's defense. 5 takeaways from the application for payment cycle. The architect certifies, not approves, not guarantees, not warrants, to the best of the architect's knowledge, that the work has progressed and the quality conforms to the contract documents. That word certify is what holds the defense in a future lawsuit, and it only holds if the certification was actually performed responsibly. The 6-step monthly cycle runs from contractor application through architect review and certification to owner payment, and the cycle repeats every month with a fresh professional representation each time. The contractor prepares G702, G703, and the schedule of values. The architect approves the SOV at the start of the project and certifies the lower portion of G702 each month. The schedule of values is the line item baseline against which every subsequent application is measured, so architect approval at the start carries outsized weight for the rest of the project. And the bottom line rule that holds the certification's defense is to certify only for work actually in place. Paying ahead or certifying for materials that the architect has not verified is the most common path to insurance claims against architects in the CA phase, and the firm's premium tracks how disciplined the certifications have been. Most architects underestimate how much money is on the line in the schedule of values review at week 1 of construction. The SOV is the contractor's breakdown of the contract sum into line items, and every progress payment for the rest of the project is calculated against it. Approve a front-loaded SOV, one where mobilization, general conditions, and early site work are inflated relative to their true cost, and the owner overpays the contractor for the early months and is exposed for the difference if the contractor walks off the job. Front-loading is the most common form of payment fraud in construction, and the architect's SOV review is the only check against it. Skip the review or skim it, and the firm is the one being sued by the owner 6 months later for negligent certification. The exam tests this domain because the review work is unglamorous but high stakes, and most candidates have never had to defend a front-loaded application of pay against a bankruptcy trustee. 5 checks separate a rigorous SOV review from a rubber stamp. 5 checks separate a rigorous SOV review from a rubber stamp. First, reasonable allocation of cost to each line item. Mobilization and general conditions should reflect actual cost, not an inflated front-loaded share. Second, sufficient detail for monthly progress measurement. A single line item representing more than 3 to 5% of the contract sum is probably too big and should be broken into sub-items so percent complete can be verified objectively. Third, separation of material and labor where needed, because stored materials applications require a clean material number that the architect can verify independently of the installed work. Fourth, every line item of the contract work is included and the total equals the contract sum exactly. Missing items create disputes at closeout when the contractor argues some piece of work was never priced into the breakdown. And fifth, consistency with the contract documents. The SOV scope should match the specifications and drawings line by line, so the percent complete on a line item maps to a measurable piece of the actual building. 4 tells signal a front-loaded SOV. Train yourself to spot them at week 1 before signing the approval. 4 tells signal a front-loaded SOV, and you should train yourself to spot them at week 1 before the approval is signed and the front-loading becomes the project's payment baseline. First, mobilization or general conditions exceeding industry norms. Most projects land between 3 and 6% of contract sum on these line items. A number outside that range without a clear reason is the contractor recovering early money. Second, site work allocated more than the visible cost of the actual site work scope. When the demolition and excavation line items together exceed what those scopes should reasonably cost, the contractor is loading dollars forward. Third, vague, high-dollar line items with no breakdown. When a single line says general conditions and the number is $850,000 with no sub-items, the architect has no way to verify the number, and the owner is exposed to the full amount on the first pay app. And fourth, early trade items priced disproportionately high relative to specialty trades, demolition and excavation inflated, and the late finishing trades like cabinetry and finishes priced suspiciously low to keep the total at the contract sum. When you see one of these tells, send the SOV back with specific questions. The discipline is to send it back, not to sign it. Pulling the checks and the tells together leaves one rule that holds the architect's certification defense. 5 takeaways from the Schedule of Values review. The SOV is the contractor's breakdown of the contract sum into individual line items, and every monthly progress payment for the rest of the project is calculated against it, which makes the week 1 approval one of the highest stakes architect decisions on the project. The contractor prepares the SOV and the architect approves it. The 5 checks the architect runs at approval are reasonable cost allocation, sufficient line item detail, separation of material and labor where needed, completeness with totals matching the contract sum, and consistency with the contract documents. The front-loading tells to watch for are inflated mobilization and general conditions, oversized vague line items, and disproportionately high pricing on early trades relative to specialty trades. And the bottom line rule is to send a front-loaded SOV back with specific questions. Never sign it as a professional courtesy, because that signature becomes the basis for the negligent certification lawsuit if the contractor walks off the job with the owner's money already in his pocket. Most architects can recite the retainage percentage from memory and yet still get the closeout question wrong on the exam. Retainage is the percentage withheld from each progress payment, typically 5 to 10% depending on jurisdiction and contract, and the owner holds the withheld money as security for completion. The reason retainage matters is that it is the only real hold the owner has at the back end of the project, when the contractor is 99% done and stops responding to closeout requests. Without retainage in the bank, the owner is reduced to begging or suing. With retainage in the bank, the contractor finishes the punch list. The companion topic, stored materials, is the architect's most common path to certifying for materials that never arrive. The supplier's warehouse burns down. The trucking company goes bankrupt before delivery. The materials are tagged but never shipped.
The owner has paid for goods the project will never see, and the certifying architect personally is named in the insurance claim that follows. Both topics live in AIAA 201, sections 9.3, 9.8, and 9.10, and the exam tests them as a unit. 6 facts about retainage that frequently appear on the exam. Commit them to memory. 6 retainage facts the exam tests, and you should commit each one to memory. First, retainage is a percentage withheld from each progress payment as security against incomplete or defective work. Second, the typical amount is 5 to 10% per payment, with the exact percentage set by jurisdiction and by the contract. And many state statutes cap the maximum allowable retainage, which the supplementary conditions must respect. Third, the purpose is two-sided. It incentivizes the contractor to complete the work, and it provides the owner with funds to correct deficiencies if the contractor fails. Fourth, reduction at substantial completion is common. Many contracts reduce retainage at that milestone to 150% of the value of remaining incomplete work, which rewards the contractor for reaching the milestone while still preserving the owner's hold on the punch list and closeout items. Fifth, final retainage is released with the final payment, only after all contract requirements have been fulfilled, including punch list completion, final documentation, and warranty information. And sixth, many states regulate maximum retainage percentages by statute, so the contract retainage cannot exceed the statutory cap. Stored materials are the architect's most common path to certifying for goods that never arrive. 5 safeguards prevent the lawsuit. 5 safeguards stand between the architect's certification and a stored materials lawsuit. First, materials must be properly stored and protected from physical damage. Outdoors in the rain or unsecured in an unlocked warehouse is not acceptable storage. Second, insurance must cover the materials specifically, and the owner must be named as additional insured on the policy so a claim can be made directly if the storage facility burns or floods. Third, invoices, delivery tickets, and storage records must be on file. Paper proof that the materials were actually purchased and actually delivered to the storage location, not invented for the pay application. Fourth, off-site storage requires bills of sale transferring title to the owner before the architect certifies payment, because without title transfer, the owner is paying for materials that legally belong to the contractor's supplier. And fifth, the architect verifies that the materials exist and are properly stored before certifying. This is one of the rare cases where the architect should physically check, not rely on the contractor's representation, because a contractor sued for fraud claims he meant to deliver. Many experienced architects recommend against paying for off-site stored materials at all, unless every one of these safeguards is airtight, and that recommendation is defensible on professional liability grounds. Pulling retainage and stored materials together leaves one rule that holds the certification's defense at closeout. 5 takeaways from retainage and stored materials. Retainage is typically 5 to 10% withheld from each progress payment and is the owner's only meaningful hold at the back end of the project. Without it, the contractor has no contractual reason to chase the punch list to closure. Reduction at substantial completion is the common contractual move, typically to 150% of the value of the remaining incomplete work. That rewards the milestone while preserving the owner's hold on the remaining items. Many states cap maximum allowable retainage by statute, so the contract must respect the statutory limit, and the architect should know the cap in the project's jurisdiction. Stored materials payment requires 5 safeguards: proper storage, insurance with owner named as additional insured, complete documentation, bills of sale transferring title for off-site storage, and architect verification. And missing any one of them is the lawsuit waiting to happen. And the defensible professional recommendation is to advise against paying for off-site stored materials unless all 5 safeguards are airtight, because the firm gets sued personally for every off-site stored material certification that turns into a loss for the owner. Most architects answer the special inspection question wrong on the first try because the intuition is wrong.
The intuition says the contractor builds the work and the contractor should arrange the testing of the work. The contract says the opposite. Per AIAA 201, Section 13.5, the owner, not the contractor, selects, employs, and typically pays for the independent testing agency that performs special inspections on the project. The reason is independence. If the contractor selected and paid the testing agency would be the contractor's contractor, and the conflict of interest would defeat the whole purpose of independent verification. IBC, Chapter 17, governs the structural special inspections in jurisdictions that adopt the IBC, and the Statement of Special Inspections, typically prepared by the structural engineer of record and made part of the permit set, identifies which elements require continuous inspection, which require periodic inspection, and what qualifications the inspector must hold. The building official approves the inspection agency before work begins and receives the final report after completion. Get the chain of authority wrong on the exam, and the question is dead. Get it wrong on a real project, and the firm gets sued for negligent oversight when a covered-up failed test surfaces years later. 6 roles in the inspection chain, and each one belongs to a different party. 6 roles in the inspection chain, and each one belongs to a different party. The code and the contract documents specify what must be tested. The architect and the structural engineer write the Statement of Special Inspections, and the IBC requires the listed inspections by element type. The owner pays for code-required testing per A 201, Section 13.5.1, unless the contract says otherwise. The contractor pays for spec-required testing when the testing is explicitly part of the specified work. Testing that is part of the contractor's quality control program is the contractor's expense. The owner selects the testing agency, which must be independent of the contractor. The contractor does not pick its own checker. The independent accredited lab performs the tests and reports directly to the owner and the architect, not to the contractor. And the building official, the authority having jurisdiction, approves the inspection agency before work begins and receives the final report after completion, per IBC Chapter 17. 6 lanes, 6 parties, no overlap. 6 common special inspections show up on almost every project, and the uncovering rule decides who pays when something is covered before it is inspected. 6 common special inspections appear on almost every project, and the architect should know the list by heart. Structural steel inspection, covering high-strength bolting and welding, is the typical first inspection on a steel-framed building, and the inspector tests bolts and welds for conformance to the structural steel specifications. Concrete is the broadest category. Placement, reinforcement, sampling, slump testing, and break testing of cylinders for compressive strength. Masonry inspection covers grout placement and reinforcement verification and applies on most masonry walls and bearing structures. Soils inspection covers compaction and bearing capacity testing and happens before footings and slabs are poured. Fireproofing inspection covers spray-applied fire-resistive material thickness and density and is the inspection that ends careers when it is missed and a fire reveals under-applied protection. And the hard rule across every inspection category is the uncovering rule. If the contractor covers inspectable work before the required inspection, the contractor pays to uncover the work, conduct the inspection, and recover the work at the contractor's own expense. Failed test results trigger a documented response sequence. The contractor receives the failed report, proposes a remedial action, and may not cover or proceed past the affected work until the architect, in coordination with the engineer of record, accepts the remediation. Covering up failed work to deal with it later is one of the most common sources of catastrophic construction defects, and one of the easiest to prevent through prompt review of test reports as they arrive. Pulling the chain of authority and the inspection list together leaves one rule that holds the architect's defense. 5 takeaways from special inspections and testing. The owner selects and pays for the testing agency, per AIAA 201, Section 13.5, and the testing agency is independent of the contractor. That independence is the whole point of the system, and a contract that lets the contractor pick the inspection agency is a contract that has defeated its own quality assurance mechanism. The agency reports directly to the owner and the architect, not to the contractor, and the architect's job is to review the reports as they arrive, not to wait until closeout when buried failures are no longer easy to fix. IBC Chapter 17 governs structural special inspections in jurisdictions that adopt the IBC, and the authority having jurisdiction approves the inspection agency and receives the final report. The 6 common inspections, steel, concrete, masonry, soils, fireproofing, and structural wood, appear on almost every project, and the architect should know them by heart.
And the uncovering rule is the financial lever. When the contractor covers inspectable work before the required inspection, the contractor pays to uncover, inspect, and recover at the contractor's own expense every time, because covering up failed work to deal with it later is the path to lawsuits the firm cannot defend. Most architects on their first defect dispute want to order the work torn out, and the contract will not let them do it. Per AIAA 201, Sections 4.2.6, 12.2, and 12.3, the architect's authority is to recommend rejection of non-conforming work, not to enforce it. The owner enforces. The chain is the architect identifies the non-conformance. The architect notifies the contractor in writing. The architect recommends rejection, and the owner, as the party to the contract with the contractor, directs the rejection. If the contractor refuses, the matter routes into the claims process under Article 15. The other half of the rule is the basis for rejection. The architect's authority to recommend rejection is limited to non-conformance with the contract documents. The architect cannot recommend rejection because the finish looks wrong to the architect's eye, or because a detail could have been built better, or because the architect would have specified differently. Personal preference is not a basis for rejection, and the architect who recommends rejection on personal preference grounds gets sued for tortious interference with the contractor's contract. 6 steps separate observation of non-conforming work from corrective action. Walk them so the architect's role at each step stays clean. Walk the 6 steps so the architect's role at each one stays clean. Step 1. The architect observes the work and compares it to the contract documents, not to the architect's personal preference, not to what would have looked better, but to the specifications and drawings that the parties agreed to. Step 2. The architect notifies the contractor in writing, specifying the non-conformance and the contract document reference that establishes the standard. Verbal observations in the field are not enough. The written notice is what survives a later dispute. Step 3. The architect may reject the work or require additional testing, per A201, Section 12.2.1. The architect's authority extends to ordering tests that confirm or refute the non-conformance, with costs borne by whichever party turns out to be wrong. Step 4. The contractor corrects at the contractor's own expense, because conformance with the contract documents is the contractor's responsibility, not the architect's. Step 5. If the contractor disputes the rejection, the matter routes into the Article 15 claims process, starting with the 21-day written notice. And Step 6 is the uncovering rule. If the correction reveals additional defective work, the owner may, on the architect's recommendation, order further uncovering at the contractor's expense. The cost responsibility table for testing non-conforming work is one of the most heavily tested patterns in the CE division. The cost responsibility table for testing non-conforming work is one of the most heavily tested patterns in the CE division. 3 situations, 3 cost outcomes, all driven by the same underlying rule. The party whose assumption was wrong bears the cost. When the work fails the test and turns out to be non-conforming, the contractor pays for the testing and the correction. The contractor was wrong about the work, and the contractor pays.
When the architect orders testing and the work passes the test, proving the architect's suspicion was unfounded, the owner pays for the testing because the test was ultimately unnecessary. The architect was wrong about the work, and the owner, on whose behalf the architect was acting, pays. And when the contractor covered work before a required inspection, the contractor pays to uncover, test, and recover regardless of the outcome, because covering inspectable work before inspection is itself a contract violation. The rule reduces to a simple test. Identify the party whose assumption turned out to be incorrect, and that party pays. The architect who can explain this rule cleanly on the exam will get the question right every cycle. Pulling the rejection chain and the cost rule together leaves one principle that holds the architect's authority within bounds. 5 takeaways from non-conforming work and rejection. The architect's authority is to recommend rejection, not to order it. And the owner is the party who actually enforces the rejection because the owner holds the contract with the contractor. The basis for rejection is non-conformance with the contract documents, not the architect's personal preference or aesthetic opinion. Recommending rejection on preference grounds is tortious interference, and the architect personally is sued for it. Written notice to the contractor with the specific contract document reference is the procedural requirement. Verbal observations in the field are not enough and do not survive a later dispute. The cost rule for testing reduces to a simple principle. The party whose assumption turns out to be wrong pays for the testing, and that rule produces clean outcomes in all 3 common scenarios. And the uncovering rule applies whenever the contractor has covered work before a required inspection. The contractor pays to uncover, test, and recover regardless of the outcome, because the contract requires inspection before covering as an independent contractual duty. Most architects have heard the rule that means and methods belong to the contractor. And yet, under field pressure, architects cross that line every week. The reason matters. Under AIAA 201, Sections 3.3, 3.7, and 10.2, the contractor is solely responsible for construction means, methods, techniques, sequences, procedures, and safety precautions and programs. The architect's observation does not substitute for the contractor's quality control program, and the contractor's quality control program does not substitute for the architect's observation. They are 2 separate duties assigned to 2 separate parties, and the contract draws the line specifically. Cross the line. By directing how the contractor sequences trades, by inspecting in the OSHA sense, by supervising labor, by taking a hammer out of a worker's hand and showing him how to swing it, and the architect picks up liability that the contract specifically assigned to the contractor. When the worker falls off the scaffold an hour later, the architect personally is in the lawsuit, because the architect's instruction is what the plaintiff's lawyer uses to argue that the architect assumed responsibility for the work crew. The exam tests this line in every CE division, because it is the single most expensive line architects cross. Side by side, the contractor's responsibilities and the architect's role are 6 items each, and the columns do not overlap. Side by side, the 2 columns do not overlap. The contractor supervises and directs the work using qualified personnel. The architect does not. The contractor ensures the work conforms to the contract documents. The architect's role is to observe whether it does, not to ensure that it does. The contractor coordinates all subcontractors. The architect does not direct the contractor's coordination, and any attempt to do so absorbs the contractor's coordination liability. The contractor provides quality control through self-inspection. The architect's observation is a separate duty, not a substitute. The contractor corrects non-conforming work at the contractor's own expense. The architect identifies the non-conformance, but does not pay for the correction. And the architect's role, in the second column, is to observe general conformance during site visits, review submittals for design intent, identify non-conforming work when observed, recommend rejection of defective work, certify payment based on observed conformance, and report observed safety hazards to the owner and contractor. The architect observes safety hazards because the architect is on the site. The architect does not enforce safety, which remains the contractor's responsibility under Section 10.2. 6 ways to keep the line clean in the field. Train the team on each one or absorb the liability.
6 rules separate architects who keep the line clean from architects who pick up the contractor's liability. First, never say "weld it this way." Describe the design intent in the RFI response and let the contractor's engineer choose the means. Second, never sequence trades for the contractor. Sequencing belongs to the contractor's superintendent, and any directive that puts trade A before trade B is means and methods. Third, never select equipment. Pick points, lift methods, and equipment choice are the contractor's call, not the architect's. Fourth, never stop work. Only the owner has authority to direct work to stop under the contract, and the architect who stops work in the field has exceeded contractual authority and exposed the firm to a delay claim. Fifth, route design intent direction through an ASI or an RFI response, never through a verbal exchange in the field that nobody can reconstruct 2 years later in a deposition. And sixth, remember that the architect's failure to observe non-conforming work does not relieve the contractor of the obligation to correct it. The architect's observation is a service to the owner, not a service to the contractor. And the contractor cannot use the architect's missed observation as a defense to the contract requirement to build per the documents. Pulling the line together leaves one rule that holds the architect's professional liability position for the entire CA phase. 5 takeaways that close out the CE foundational module. The contractor is solely responsible for the means, methods, techniques, sequences, procedures, and safety of construction. That is the contractual ceiling, written into AIAA 201 sections 3.3, 3.7, and 10.2, and it is the single most heavily tested concept in the CE division. The architect observes general conformance with the contract documents during site visits, and that observation never substitutes for the contractor's own quality control program. 6 contractor duties and 6 architect role items with no overlap between the columns, and the exam will put architects in the contractor's column and contractors in the architect's column as wrong answer traps. Crossing the line, directing means, methods, sequencing, or safety absorbs the contractor's liability for the directive given, and the architect personally is named in the lawsuit when an injury follows. And the rule that protects the contractor's continuing obligation? The architect's failure to observe non-conforming work does not relieve the contractor of the duty to build per the contract documents. The architect's observation is a service to the owner, not to the contractor, and the contractor cannot use a missed observation as a defense to defective work. Construction administration is one instrument played in 3 positions, and the most useful thing this module does for you is name the limits the AIA contract draws around each one. Position 1 is the architect's own role on site. The verb in B101 section 3.6 is observe, and that verb closes off inspection and supervision liability the moment it is signed. Position 2 is the 3 primary workflows of the phase: submittal review, RFI clarification, and change order administration, and each one has the exam-tested boundary the prompts keep returning to. Position 3 is the certification authority that protects the project economically, application for payment, retainage, and the rejection of non-conforming work. The thread you carry through all 3 positions is the same. You retain procedural authority while the contractor retains the means and methods of building. Mix the two, and you have just assumed liability the contract was carefully written to keep on the other side of the table. The exam tests where that boundary sits, in every quiz, on every certificate. Open with the role itself, because every workflow and every certification flows from getting that distinction right. 4 anchors define position 1. Observe versus inspect versus supervise is the verb question the exam returns to repeatedly. AIA B101, Section 3.6.2.1 says the architect observes the work to become generally familiar with progress and quality, and that single verb choice closes off the inspection and supervision liability that would otherwise attach. Interpreter of the contract documents is the architect's role when a dispute arises between owner and contractor. AIA A201, Article 4, makes the architect the initial decision maker, and that decision can be appealed to mediation but cannot be bypassed. Site visits are periodic rather than continuous. The field reports document conditions observed and discussions held, and the field report itself becomes the evidence trail if the work later goes wrong. Means and methods sit entirely with the contractor. Construction techniques, sequences, safety, scheduling of trades, and the architect who reaches into that lane has just assumed liability the contract was carefully drafted to keep on the other side. From the role itself, Position 2 is the 3 primary workflows that shape what the architect actually does day to day. Position 2 carries 4 workflow disciplines that the exam returns to. Submittal review is conformance with design intent only. AIAA 201, Article 3.12 sets the standard, and the architect who marks dimensions on a shop drawing has just assumed coordination liability that belongs to the contractor. The RFI process is clarification of design intent only. A clarifying question gets a clarifying answer, but an RFI that proposes a substitution or expands scope must be routed through the change order workflow, or the architect has authorized a scope change without the owner's signature. The change order, G701, requires 3 signatures: owner, contractor, and architect, before any scope, time, or cost shift becomes part of the contract, and the absence of any one signature means the work proceeds at risk. And the CCD versus minor change distinction is the architect's tool when the owner wants the work to proceed and the contractor disputes the cost. The CCD directs the work and lets the cost dispute resolve later, while a minor change moves the work forward only when it does not affect cost or time. Position 3 closes the module. Certification authority converting procedural observation into economic decisions on the project. Position 3 holds 3 certification disciplines, and each one converts procedural observation into an economic decision on the project. Application for payment under G702 and G703 means the architect reviews the contractor's pay application against observed progress and certifies the amount actually earned, not the amount invoiced, and not the amount the contractor expects. The certification is itself an opinion of value, and the architect who certifies without observing has stepped past the procedural authority the contract grants. Retainage is the owner's holdback against incomplete or defective work, typically 5 to 10% of each progress payment depending on the contract, released at substantial completion once the punch list is verified. And non-conforming work is the architect's authority to reject, in writing with reasons referencing the contract documents. If the owner wants the non-conforming work anyway, the resolution is a deductive change order that documents the reduced value and the owner's acceptance, never a silent acknowledgement that the work passes. 4 module takeaways carry the foundational construction administration arc into every project where you sit in the architect's chair. 4 module takeaways close the foundational construction administration arc and let you carry the 3 positions out of the module as a single posture. First, the architect observes the work, never inspects, never supervises, and never directs means and methods. And the verb choice in AIAB 101, Section 3.6 is the contract language that protects the design team from contractor liability. Second, submittal review is conformance with design intent only, not fabrication accuracy and not quantity verification, because those belong to the contractor under A201, Article 3.12. Third,
The RFI process is clarification only. A question that proposes a substitution or expands scope routes through the change order workflow under G701, or the architect has authorized a scope change without the owner's signature.
Fourth, pay applications under G702 and G703 are certified on the architect's observed progress, not on the contractor's invoice alone, and retainage of 5 to 10% protects the owner until substantial completion. The thread that holds all four together is the paper trail. The form, the signatures, and the routing are all tested on the exam because that is what protects you when the project becomes a dispute a year from now.